Just
You
done that.
understand? Pardon?
I just did that this morning.
Okay, so you gave him, okay, very good. I'll adjourn it to June 18th, 2026, 9 a.m. Thanks, Judge. Thank you. Court calls the case versus Warren Abbott.
Assistant Public Defender, Cedric the Entertainer. On behalf of Mr. Warren Abbott, I believe, is he on Zoom, Judge?
Yes, he is.
Hey,
Mr. Abbott, state your
me,
name.
Excuse me, everyone.
Thank you.
Can you hear me?
I can hear you.
Say, by the way, may you place the camera on my floor. You will see a core of an apple.
Okay.
That is how much they've been starving me. I've had about 10 to 15 meals since I've been here. This is a county system. I have not been to jail.
Okay. I'm sure we'll have your attorney look into that.
The first part of this system is called jail. The second part is called the county. And after that is the state. I have not been to jail.
Okay. We'll get all of that rectified. You're asking for a forensic evaluation?
I am, Your Honor.
Forensic evaluation will be ordered. I'll set a competency hearing date, and I've signed the order for
August 27th.
August 27th, 2026, 9 a.m.
Okay.
Bond continued.
Okay.
Thank you, Mr. Abbott.
He's Judge.
Court calls the case, People versus Jaquia Dunlap.
Your Honor, Raymond Cook for the people. Assistant Public Defender Jay Bellinger on behalf of Mr. Dunlap, who is approaching. Mr. Dunlap, can you please state your name for the record?
Jacques Dunlap.
Your Honor, if we could briefly approach on this, is that we're hearing a violation. I did receive that this morning. It's not far off from what my client and I discussed. I would just add, I'm learning from that situation. My client does currently work at Underground Printing on Whitaker Road. He has a really good job there. My understanding is that he would be able to keep that job. He has one daughter who is going to be turning 3 on June 7th. He would ask to be out for that. He's also got 2 other boys as well that he takes care of. One's 10, the other is 5. He financially supports all 3 of those kids. He just made his child support payment for 2 of his children and would definitely like an opportunity, should the court so allow, to be out so that he doesn't end up with a felony non-support. As a result of that, he is willing to wear a scram tether, GPS tracking tether, whatever the court might provide for safety to himself and the public. He does have the support of his sister and his girlfriend who are here today. His girlfriend did also write the court a letter speaking to that. Alternatively, Your Honor, if the court is unwilling to release him, I have talked to Mr. Cook. We would be asking for a release in patient treatment once a bed becomes available.
I will sign an order. I don't need a response. I'll sign an order for inpatient treatment. Once that's presented to the court, I don't have a problem doing that.
Okay.
With regard to his release at this point, I am disinclined to do that, so I'm going to deny that request. And his bond will continue, and certainly after the exam, the examination judge can relook it.
Certainly. All right. Thank you very much.
Court calls case of People versus Lamar Butler.
I'll do an order for me. Hi. Assistant Public Defender Jay Bellinger on behalf, but not with Mr. Butler. Your Honor, my client is listed as homeless. He doesn't have a phone number or a valid email or any way that I can reach him. I understand that we did a warrant recall last time. He didn't show up. He does call our office after the fact. Unfortunately, no one collected a number from him that I could reach him on. So I will be working on getting one of those. I don't know if the court would at least consider another warrant recall should I end up in touch with him.
Any response from the people? Oh, all right. Here he calls. I see that he has done the recall. and then somehow or another things are lost.
My understanding last time he was here was that he was informed by another defendant who was before this court, who saw him in person after court and let him know that he had a court hearing. He did call our office after the last bench warrant recall. We did, to the best of my knowledge, give him the date for today.
Normally, I would issue a bench warrant. What I'm going to do in this case, I'll continue his bond. Give you 2 weeks to get him here.
Okay,
11, 2026.
thank you very much.
Court calls the cases 1, 2, 3, 4, 5, 6. Well, no, 4. Well, 6 on behalf People versus Gerard. Uh-oh.
Ashley Hannibal for the defense, Your Honor, requesting permission to practice,
Speak up, speak up, speak up.
requesting permission to practice pursuant to Michigan Court Rule 8.120 under the super
Who wrote that down for you?
canon.
Oh, you're with Cannon?
Yep.
I'm sorry. Okay. Go ahead, you can finish.
Under the supervision of Assistant Public Defender Stephanie Cannon.
Got it. All right. Where'd you go to undergrad?
Michigan, Your Honor.
Where are you in law school?
Minnesota.
What?
University of Minnesota, Your Honor.
I should Minnesota? Golden Gopher.
Yep.
Okay. Where are you from?
Michigan.
Okay. Do people actually go to Minnesota? I like Minnesota. Everything's underground. Permission practice is granted.
All right, thank you.
Your name, sir?
Brian George.
Thank you. All right, what are we doing?
We'd like to set preliminary examination on all 6 matters.
Okay. Discovery is complete.
I believe so, Your Honor.
And would the people have their witnesses available on tonight? All right. Who has to do this? Preliminary examination in all 6 matters will be set for June 9th, 2026, 9 a.m. That's before Judge Barr.
All right.
All right, Bond will. Thank you.
I was released to treatment and.
All right, he's gonna have to move. Court does call the case of the people of the state of Michigan versus Sean Call.
Assistant Public Defender Davi Lebo from Mr. Call. Mr. Call, can you tell the judge your name?
Sean Call. I have before me a plea form that it indicates that the defendant will be pleading guilty to the charge of larceny less than 293-day offense. Upon a successful plea to that charge, count 1 would be dismissed. And defendant agrees to restitution to be paid at the time of sentencing. That's the court's full understanding of the agreement.
That's correct, Your Honor.
May I have him sworn?
Right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
State your name, please.
Sean Call.
Sir, it is this court's understanding that you're going to plead guilty to the charge of larceny less than $200. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. You understand also, sir, that while in taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form. Is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on them.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, I am.
And because you believe that you're guilty of this offense?
Yes, Your Honor.
September 8, 2025, at the location of 328 South Fifth Avenue in City of Ann Arbor, Washtenaw County, State of Michigan. What'd you do that makes you think that you're guilty of that offense?
I bought some groceries at the store with a card I had found in the street and a wallet with no money in it.
Okay, so prior to you going into the store, you're saying that you found a wallet?
Yeah, I got off the bus on Gulf Side in between Platt and Washtenaw, and there was a wallet in the middle of the street, no money. And I think I had gone to Kroger's or Myers and bought some cat food, and the cards I used didn't work. I kept using cards that I had, and I guess, I used that one, and I used my ID. So, obviously it came back to me. So guilty.
Your Honor, may I,
Oh,
but here,
Please.
Sorry.
Mr. Call, on the date and time the judge discussed, did you use a Cash App card at the Kroger?
Yes.
And was that your Cash App card?
No.
Did you buy cat food with it?
Yeah.
Oh, and had anyone given you permission to use that Cash App card?
No.
Yes, sir.
Thank you.
All right. Sir, I do have to advise you that if I accept your plea and you commit misconduct between the time I accept your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
All right. People aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. Thanks.
And none from defense?
And have I complied with the court?
Yes.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be June 16th, 2026, 8:30 before Judge Perry. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case. People versus Amanda James.
Court shall please to assist them. Is there? Please answer the record.
Amanda James.
Thank you, Judge. I believe we are requesting to have this matter adjourned if we are still in negotiations. And I believe Ms. James does want me to address her bond again.
Preliminary or probable cause will be adjourned to June 11th, 2026, 9 a.m.
Thank you very much.
As the bond.
Thank you, Judge. I believe Ms. Gaines argued bond for Ms. James last time she was, and I believe she asked that Ms. James be allowed to be released on a tether or released back to her home. She indicated that Ms. James would return to court. She understands the severity of the matter. She does not believe she's a flight risk, and she understands that the court had previously denied this request. But Ms. James is hoping to get this matter resolved with a plea agreement that I'm going to work with Ms. Feltus, I believe, to get that resolved. But we have not yet reached appropriate terms. She's asking for the court to reconsider low cash or personal bond.
Respond. Where is she residing current? I mean,
1282.
where would she reside?
So my home address is 1282 Medford Drive, Ypsilanti.
Okay. So that's where you would reside?
Yes, sir. Yes, Your Honor.
I'll grant a release in this case. Set her bond $10,000 personal recognizance bond. Defendant, however, must report to community corrections to be placed on a GPS location tracking time.
Thank you, Your Honor.
So much, Judge.
Thank you.
All right.
At prior to release. Court does call the case People versus Tyler Foland.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Foland. Foland, could you please state your name for the court?
Tyler Foland.
You're requesting an adjournment.
Yes, Your Honor.
Public cause conference will be adjourned June 18th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continue. Thank you. Court calls case People versus James Jones.
Ready to go for the clear eyes?
Yep.
Yes. Talk about that later, okay? Assistant Public Defender Jay Bellinger on behalf of Mr. Jones. Mr. Jones, can you please state your name for the record?
James Jones. Thank you.
And Your Honor, we are just asking to set this matter for preliminary examination. Discovery is complete now, to the best of my knowledge.
All right. People have their witnesses available to 9.
Did you get any information about the dash? Part of that?
Their examination,
I have all the-
2026, 9 a.m. for Judge
Part of dash though?
Judge Garwood.
I want the Carter Dash report from him calling the dispatch, Carter dispatch. That's what I need.
Your Honor, would ask for a PCC at this point, considering another request I'm just getting from my client. I apologize.
I'm sorry, I called.
No, it's okay. So you need an adjourned date?
I would.
Okay. I'll adjourn the matter, the PCC, I'll adjourn it to June 11th, 2026, 9 a.m.
Call my office tomorrow again so I can talk to you myself, okay?
Yes, sir.
All right.
Thank you. Court does call the case People versus Taylor Godfrey.
Brian Williams, we have this guy to Your Honor. Can you state your name for the record, please?
Taylor Godfrey.
All right. Judge, oh, I'm sorry, go ahead.
We have before me a plea form. Is that what we're doing?
That's what we're gonna do. That's what I was gonna say.
Form indicates that she'll be pleading to an added count 3 of use of a controlled substance, a 1-year offense. That's a no contest plea. Upon her successful plea to that, counts 1 and 2 would be dismissed. There's a sentence agreement as to sentencing under 7411. That's the court's full understanding of the agreement.
That's correct.
That's my understanding as well, Judge.
May I have her sworn?
Right, and do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing so help you God?
Yes.
State your name, please.
Taylor Godfrey.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to or pleading no contest to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
Yes.
All right. Do you understand what a no contest plea is?
Yes.
All right, 2 things about it. Have to make sure that you understand it. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? All right. You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court.
I understand.
You understand that? All right. So basis of the no contest plea.
Potential civil liability related to some of the dismissed counts, Your Honor.
So ma'am, as to that charge, how do you plead?
No contest.
Now you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct?
Yes.
Any question regarding those rights? Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights in that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
Court has been provided and has reviewed Chelsea Police Department report for their case number 2659. Any objection to the court having that report?
No objection from me, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, I do have to advise you, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that? Is counsel aware of any other promises, threats, or other inducements which are led to this plea?
I'm not aware of any, Your Honor.
And have I complied with the court rule?
Yes, sir.
You have.
Court will accept the defendant's no contest plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing will be
5, 6, 7, 8.
July 6, 2026, 9 a.m. before Judge Fresha. Fine. Thank you. Call me if you need anything. Thanks, sir. Court calls the case, People versus Christopher Kelly.
Actually, Hannibal for the defense, Your Honor.
You're requesting an adjournment. Your name, sir?
Christopher Kelly.
All right. You're requesting an adjournment.
That's correct.
Without objection, June 11th, 2026, 9 a.m.
All right, thank you, Your Honor.
Court calls the case, People versus Sean Charles.
Your Honor, ring people. Michael Gaddy, Assistant Public Defender on behalf of Ms. Charles, Your Honor. It could be present via Zoom, Judge.
We have it. Oh. State your name, please, ma'am.
LaShawn Charles. Good morning.
Good morning. Your request.
Yes, Your Honor, the people have made an offer I would like to discuss with Ms. Charles, and there's an ancillary matter I need to look on.
I'm sorry.
An ancillary matter that I need to look in.
All right. I'll adjourn the matter to June 18th, 2026, 9 a.m.
Thank you, Judge.
Bond continues.
I'll give you a
Thank
call,
you.
Ms. Charles. I've got
Thank you. Yeah, I was there. Not yet. Court calls the case of the People versus Hetty Diaz.
Assistant Public Defender Davi Liebe on behalf of Ms. Diaz.
Good morning, Your Honor.
Good morning. State your name.
My name is Hetty Diaz.
All right.
Andrew, I'm going to be requesting adjournment. And Ms. Diaz, still some questions you'd like me to answer.
All right. Matter will be adjourned June 18th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Court calls the case, People versus Merrick Lincecum.
People, Your Honor.
Assistant Public Defender Davi Liebe on behalf of Mr. Lincecum, who approaches. Mr. Lincecum, can you tell the judge your name, please?
Good morning, Your Honor. Merrick Clayton Everett Lincecum.
Thank you. And Your Honor, we're going to be requesting adjournment to continue negotiations. I did also want to address bond.
All right.
Thank you, Your Honor.
I'll adjourn it to the 11th.
Thank you, Your Honor.
Bond.
Regard bond, Your Honor, I'm going to be requesting a release to treatment. At the time of the failure to appear in this matter, Mr. Lincecum explained to me that he was unhoused. He was staying with a friend, had lost his phone. He was explained to me he was very much focused on survival and day-to-day distance at that time. He has told me, and to me it sounds very sincere, that he believes his legal problems, at least his mental health problems, come from his drug use. He described me, he does have some.
You're requesting release to treatment?
Yes, Your Honor.
Any objection? I'll sign an order release to treatment with a tether.
Thank you, Your Honor. I'll submit an order.
Thank you.
Thank you so much, Your Honor. Have a great day.
You too. Court calls the case, People versus Raymond McCarthy.
Michael Gaddy, Assistant Public Defender on behalf of Mr. McCarthy, Judge. Should be approaching from Papa.
Okay. There's. Yeah.
Yes, it's the rest of it. There's sneeze in the system.
Your name, sir?
McCarthy.
Okay.
Your Honor, I believe we'd like to set this matter for a preliminary examination.
Discovery is complete.
To the best of my knowledge, Judge.
People have their witnesses available tonight.
Try, Your Honor. Thank you.
Preliminary examination, June 9th, 2026. 9 a.m. before Judge Garwood.
Your Honor, if I could be heard on bond.
Briefly.
Yes, Judge. Mr. McCarthy is here. He was picked up here in Ann Arbor. He didn't know there was a warrant for his arrest. He reports that he doesn't know anything about this matter. He reports that he does have a place to reside, that he resides in Detroit. I can give the court that address where he's lived for many, many years. He lives with his brother and adult children. He is not employed, but he does receive Social
disability. I believe it's SSDI. I don't think he's a flight risk in that. I don't think he's going to leave the state of Michigan or anything like that. I don't know.
How did you not know he had a warrant?
Yeah, I don't know if this is an identification case or what. But may we approach briefly?
Oh, after he failed to appear.
Yes, Judge. May we approach briefly?
This probably won't get any better, but yeah, come on.
Thank you for the bench conference, Your Honor. I'm not trying to gild the lily here. I am informed now that there are 3 other matters that may be pending or soon to be pending. I would note that there is nothing charged and there's the presumption of innocence.
Don't need a response out loud from the people. Motion for bond reduction is denied. We'll continue. Pardon? Did I not do that again? It's before Judge Garwood.
I'll come see. Oh, I'll come see it and I'll show you.
Court does call the case, People versus Matthew Frazier.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Frazier, who is here to my right, Judge.
Your name?
Matthew Frazier.
All right. What are we doing?
Well, Your Honor, we'd ask the court to set a preliminary examination.
Preliminary exam, discovery is complete.
Yes, Judge.
Preliminary examination will be set June 9th if the people's witnesses are available. June 9th, 2026, 9 a.m. before Judge Barr.
All right, thank you.
Thank you. Bond continue.
Hold on.
Thank you. Court calls the case, People versus Michael Moore.
Your Honor, things to the people. Fine over here.
No, can I go on behalf of the defendant, Your Honor?
Go ahead.
We're requesting an adjournment so that a mitigation parent.
He did? I didn't hear him. He needs to speak up.
My apologies, Your Honor.
Like a true pioneer high grade would do that. All right, go. Your name, sir?
Michael Spencer Moore, sir.
All right, go ahead. What are we doing?
We're requesting an adjournment so that a mitigation interview may be conducted, Your Honor.
Okay. Are you gonna be able to get that all accomplished in 2 weeks, or you need 3?
3 would be optimal, Your Honor.
All right. Preliminary or PCC will be adjourned in all matters to the 18th of June, 2026, 9 a.m.
You know, I just wanted to confirm, I saw there were 5 cases on the docket. I believe there should be 6 cases before you log in today. Does the court have 6 files or just 5?
Hey, 6.
Okay, perfect. Thank you.
All right. Thank you. On continuing each of the matters. Court does call the case. Well, probably won't have them. Court calls the case, People versus Robert Harris.
Assistant Public Defender Jay Bowen on behalf of Mr. Harris, who should be appearing via Zoom. Mr. Harris, you could state your name for the record.
Robert Harris.
Thank you.
Thank you. And Your Honor, we are just asking to set this matter for preliminary examination at this point.
All right.
Discovery is complete to the best of my knowledge.
Are there witnesses available to the 9th? All right. Preliminary examination in this matter will be June 9th, 2026, 9 a.m. before Judge Garwood.
Thank you very much.
Thank you,
Court
Your Honor.
does call versus Robin Nobles. Cedric. No. Who do you have? Noble.
Ready, Judge. Rochelle, please, first fellow defender on behalf of my client, Ms. Nobles. Please state your name for the record.
Robin D. Nobles.
Thank you.
Thank you, Judge. I did my client, speak to the people on this matter. Looks like we want to have my client evaluated for felony drug court. If we could have a two or three week adjournment to see if she's eligible.
Will they be able to get to her in 2 weeks, you think, or?
Not sure about the running right now, Your Honor, but because she's in custody, I'm most comfortable to come back in 2 weeks to see where we're at.
Okay. During all of these matters then to June 11th, 2026, 9 a.m. All right.
Okay.
All right. Thank you. Continue.
Thank you.
Court does call the case. People versus Baloney Franklin.
Bring your own agreement.
Mr. Klein, you're in Zoom. Please put that cigarette out. You're in court.
Assistant Public Defender, Chinaza Carey, I can rule, Your Honor, on behalf of Ms. Kalani Franklin. Kalani, state your name for the record. Kalani Franklin.
Thank you. I have before me a plea form. Is that what we're doing?
That is correct, Your Honor.
All right. See the scratch outs on this. The plea form indicates that she's going to plead to retail fraud 3rd degree, the 93-day offense. Upon her successful plea to that charge, count 1 would be dismissed. There is an agreement to sentencing under HIDA.
That's correct, Your Honor.
That is our understanding as well, Judge.
Yeah, have her sworn.
Right. Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
Kalani Franklin.
Ma'am, it is this court's understanding you're going to plead guilty to the charge of retail fraud into 3rd degree. That is a misdemeanor. Punishable by up to 93 days in jail, up to a $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. And I should also advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand all of that?
Yes, I understand, Your Honor.
All right. So wish to plead guilty?
Yes, Your Honor.
Well, do you want to plead guilty to this, ma'am?
No.
No. Okay. Counsel, what would you like to do?
You get a little bit more time, Judge.
That objection on the during the probable cause conference. Ma'am, this is like, I'm just gonna say this. I'm not saying it to punish you anywhere or anything bad. I adjourned it the last time because we ran into a snag. So you need to have a real frank conversation with your attorney about what you want to do. Okay? June 18, 2026, 9 a.m. Bond continued. Thank you.
So much, Your Honor.
Thank you.
Court calls the cases of the people versus Tasha Shiner.
An assistant public defender, Jay Bellinger, on behalf of Ms. Shiner, who approaches. Ms. Shiner, can you please state your name for the record?
Tasha Shiner.
Thank you.
Requesting an adjournment.
I am requesting an adjournment, Your Honor. I did just refer her for recovery court in the circuit on all 3 of her matters before you today. I am requesting a release to inpatient treatment. I understand what in talking with Ms. Veltis that she has had some issues with appearing in the past. However, given the fact that she has a lot of holds right now that my office is working to help her try to clear, I imagine that's going to take some time. So I am asking for that permission now so that we can start working towards that. And I'm hoping that even within a month, we can at least try to get her into some sort of inpatient facility.
I do have the concerns about the schools here. I have concerns about her having both other counties. I think those are active cases, at least some of them. I'm not 100% sure about that, Your Honor. So please, I'm not trying to misrepresent anything if they're closed and they're probation cases. It just feels like there's a lot going on here, and I'm not sure if getting out at this point during the treatment is the right call. I'd like to see Ms. Sample evaluate her and make a plan. And if she advises myself and Mr. Bellinger that inpatient is the next one, because then of course we can revisit. But at this point, I'm just a little concerned about what's going to happen if she gets out.
And Your Honor, like, as I stated, my only real concern with that is the amount of time, it's the sheer amount of time it's going to take to clear those holds. One's out of Alcona County. I don't even know where that's at. And so I imagine that as part of recovery court, Ms. Sample is likely going to refer her to inpatient at a certain point. And it would just be nice to be able to start working as we are on those holds and to be able to get her released as soon as we can.
Correct, but I think if the ultimate goal here would be the treatment court, I'm going to deny your request at this time for release to treatment, and her bond will continue. And I will adjourn these. We're thinking they can get these assessments and done by the 2 weeks.
I am very hopeful. I will keep up with Ms. Sample.
June 11th, 2026, 9 a.m. Bond continued.
When is that? And then be evaluated by the court team once we review it. Okay.
Court calls case people of the state of Michigan versus James Heron.
People.
Heron was assigned to Miss Gaines, but not here.
Ready, Judge. Court shall cease to assistant public defender on behalf of James Heron. Looks like I don't have a client, Your Honor. I do not know why he is not present. My interns call Mr. Heron, but apparently he's not here, Your Honor. For the record, I asked for an adjournment, but I don't know where he is.
Bench warrant will issue a bond setting around 10,000 cash surety.
Thanks, Judge.
That warrant will issue immediately. Court calls the case people versus Kyle Zimmerman.
Morning, Mayor. Michael Gagg, public defender on behalf of Mr. Zimmerman, who's approaching.
Your name, sir?
Kyle Zimmerman.
Your Honor, we're asking for a brief adjournment so I can continue discussing this matter with Ms. Felt.
Without objection, June 11, 2026, 9 a.m.
Thank you, Joe.
Bond continued. Thank you. Court calls the case people versus Kimberly Holly. I think that's it.
Brian Bowling on behalf of Miss Holly.
Kimberly Holly.
Thank you.
Judge, I'm asking this matter be set for an examination, please. All discovery is complete. Yeah.
Please. So other witnesses available at 9. Preliminary examination will be set June 9, 2026, 9 a.m. That's before Judge
Barr.
Judge Barr. Bond will continue. You're welcome. Court calls the case people versus, is it Peter Avisek? Maybe.
Stephanie Cannon on behalf of the aforementioned client. And Your Honor, I have not actually had any contact with him. I have made.
Otherwise, you know how to pronounce his name. Go ahead.
So I would ask for an adjournment in the matter.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000 cash surety. The warrant will issue immediately. Court does call the case people versus Eric Jackson.
Court shall cease to assistant public defender on behalf of Mr. Eric Jackson, who I believe is approaching.
Sir, your name?
Eric Jackson.
Thank you.
Thank you, Judge. We are requesting an adjournment for further negotiations. We've asked for 2 weeks, please, Judge.
Court will adjourn the matter June 18th, 2026, 9 a.m. Bonds. Thank you, Mr. Chair.
Thank you, Judge.
Court does call the case of the people versus Walter Junius.
Okay, I'll go on behalf of the defendant, Your Honor.
Your name, sir?
Walter Jr.
Anthony. Okay, what are we doing?
We're requesting an adjournment so that the defendant may have an opportunity to review the police report, Your Honor.
That's with reference to both cases.
That's correct, Your Honor.
Probable cause conference, June 18th, 2026, 9 a.m. All right. Thank you. Court calls case people versus Cody Klein.
And Assistant Public Defender Jay Vollinger on behalf of Mr. Klein, who appears via Zoom. Mr. Klein, can you please state your name for the record?
Cody Klein.
Your Honor, I'm just asking to set this matter for preliminary examination. To my knowledge, as of recent, all discovery is complete.
People have their witnesses available the 9th.
Okay.
Preliminary examination, June 9th, 2026, 9 a.m. before Judge Garwood. Bond will continue.
Thank you, Your Honor.
Thank you. It's all in person. Court does call the case people versus Javian Lovelace.
Your Honor, Raymond Cook for the people.
Public defender cannot to carry. I can rule, Your Honor, on behalf of Javian Lovelace. You want to know? Sure. Okay. Unfortunately, Your Honor, we have not been able to make contact with Mr. Lovelace. We were asking for an adjournment today to work out some issues with media with the people.
Yeah. No, you were talking slow, like that was gonna.
It's worked once before, Joe.
That warrant will issue defendant's failure to appear, bond set in the amount of $10,000 cash surety.
Thank you.
That warrant will issue immediately. Court does call the case of people versus Deanna Malone.
Assistant Public Defender Chinazi Carey, I can rule, Your Honor, on behalf of Kiane Malone, who should be on Zoom. Judge. Mr. Malone, state your name for the record.
Kiane Malone.
Thank you.
We respectfully request this matter be set for preliminary examination.
Discovery is complete.
To our knowledge, Judge.
Both have their witnesses available the 9th. Preliminary examination, June 9th, 2026, 9 a.m. before Judge Barr.
Thank you, Judge.
Bond continue. Thank you. Court calls the case people versus Jason Martin.
Your Honor, Raymond Cook for the people.
Stephanie can come down to Mr. Martin, who should be appearing by Zoom, Your Honor.
Hello, Your Honor.
Hello. State your name.
Jason Martin.
Thank you, sir.
Your Honor, I'm gonna ask for a brief adjournment in this matter. I just need to actually talk to my client about the case and the next steps. We were texting yesterday, but I want to actually speak with him. So, Your Honor, I'm asking for an adjournment.
June 18th, 2026, 9 a.m.
Thank you so much.
You're welcome, sir.
Have a good one.
Court calls the case people versus Erica Maxwell.
Public Defender Davey Lieb on behalf of Ms. Maxwell.
State
your name.
Erica Maxwell.
It's just, she has a bond violation. All right, what are we doing on this case?
I would like to set the matter for preliminary examination, and I am prepared to address the bond violation.
Go ahead, address the bond violation. We'll see what we'll do.
Your Honor, with regard to the bond violation, Ms. Maxwell will admit to it. She does tell me that she doesn't specifically recall drinking. She does believe she has some mental health issues that may be a factor. She does tell me that she's made contact with Catholic Charities and left a message hoping to engage in their intensive outpatient program. He asked my court to consider letting Ms. Maxwell stay out with a scram in a home confinement tether. She's explained to me that she suffers from sarcoidosis, which is a medical condition that requires a weekly injection that has to be refrigerated, that she's concerned she may not be able to get in the jail. She also indicated to me she has concerns regarding a compromised immune system. So I would ask the court to consider permitting her remain out primarily because of her health concerns.
Response from the people.
Your Honor, we will leave it in the court's discretion. We just did not have our several, or at least two missed. One missed test that I'm seeing, and then several non-compliant. So that would be our concern, but
She's blowing positive, and I mean, it's not like they were low levels. As she was coming down off of that, and then missing tests and the like. I understand everything that counsel's saying. You wanted this set for preliminary examination?
Yes, please, Your Honor.
All right. Your
And discovery is complete.
discovery is all complete.
Yes, Your Honor.
People have their witnesses available the 9th. All right. Preliminary examination in this matter will be set June 9th, 2026, 9 a.m. before Judge Garwood.
yes.
Judge Garwood. At this time, given the violations, defendant's bond is revoked, defendant's remanded.
Thank you, Your Honor.
Court calls the case People versus Kenneth Mays.
Schultz, the people.
Brian Bowling on behalf of Mr. Mays is approaching, Your Honor.
Morning, Your Honor.
Good morning, sir. Your name?
First name is Kenneth, last name Mays.
Thank you.
I'm asking for an examination, please, Judge.
All right. Preliminary examination in this matter will be set while discovery is complete.
Oh, yes, it is, correct, sorry.
Who would have their witnesses available the 9th?
Right, Honor.
All right. Preliminary examination, June 9th, 2026, 9 a.m. That is before Judge Barr.
Thank you.
Good afternoon. Joe Simon on behalf of Mr. Keene. State your name, Bill.
William Keene, Your Honor. Thank you.
Your Honor, there's a green sheet in there. The people
Go ahead.
turned over a supplemental discovery to me that I downloaded yesterday. That is, 1.6 gigabytes of information, very substantial, requesting therefore an adjournment of the probable cause.
That'd take you a night to get through.
Maybe two.
Okay. All right. Will the 18th work for you, sir?
Should work.
All right. Probable cause conference will be adjourned June 18th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the People versus Andrew Leamy.
Afternoon, Your Honor, Raymond Coach on behalf.
Where do we have counsel?
I know he was here. I spoke with him just earlier this afternoon.
I'll pass it. Court does call the case People versus Ruffini and Brooks.
Good afternoon, Your Honor. Marcia Crater on behalf of Ruffini Brooks.
You know where he is?
Well, are you Mr. Brooks? No, Mr. Brooks? Ruffini Brooks? Okay. I'm assuming he's here in spirit, Your Honor. Unfortunately, I do not have it.
They see it. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue a week.
You will not consider keeping it open to the docket. I did speak to them a couple days ago.
Keep it what?
Consider please keeping the warrant, not issuing it to the end of the docket.
Because I issued a bench warrant on a spirit.
Yeah.
Yeah, that's the reason. Yeah.
Okay, well.
All right, thanks though. Court calls the case People versus John Thomas.
Good afternoon, Your Honor. Joanne Prey on behalf of Mr. Thomas.
Good afternoon, Your Honor.
All right. Good afternoon, Mr. Thomas. I have before me a plea form that indicates that the defendant is going to be pleading to an added count 2 of OWI, operating while intoxicated occupant less than 16 years of age, a 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. There is also a sentence agreement of no upfront, or I'm sorry, 52-1 District Court Sobriety Court, and no upfront jail. That's the court's full understanding.
That's correct, Your Honor.
That's correct, Your Honor. It is a no contest plea for purposes of civil liability.
Very good. That's the one that, yes, no, it's a no contest plea. All right. Mr. Thomas, can you raise your right hand? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do so swear.
All right. State your name again for the record, please, sir.
John Thomas, John Joseph Thomas.
Sir, it is this court's understanding that you're going to be pleading no contest to the charge of operating while intoxicated with an occupant under the age of 16. That is a misdemeanor punishable by up to 1 year in jail, up to a $1,000 fine plus court costs. Court could also order any rehabilitative services or community service the court deems necessary, could order your vehicle immobilized, could order your vehicle forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
I do, Your Honor.
All right. Do you understand what a no contest plea is?
I do.
All right. 2 things about it. I just have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, I do.
The other thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, I do.
All right. You understand also, sir, that while I'm taking your plea, I would not initially be your sentencing judge in this matter, and that it would be sent over to Judge Barr.
I understand that.
All right.
I believe it's Judge Bondi. Is that what you said?
No, I don't. Okay. I knew we were going to get into this. Do I have a sentencing date for Judge Bondi? Anybody?
I do not know.
Counsel, do you know of one?
Your Honor, my understanding was that you sentenced him and that he got transferred to 52-1 for probation.
Okay. And that would be beautiful if that's the way that it worked. So what we have in this with some of these sobriety courts is some sobriety courts, if I sentence at all, they will not take the case. Then we have circumstances where there are courts that want us to do the initial part of the sentencing. We've resolved that with some of these sobriety courts, haven't resolved them with others. So that part of the resolution is once I take the plea, the person's been accepted. Once I take the plea, we just send the whole thing over, but they have given us a sentencing date. That hasn't happened in this case. So, I mean, I will do whatever the parties want me to do, but what I would intend upon doing today in this case is I would take the plea. It goes because the lower jurisdiction is Judge Barr's. It would go to Judge Barr to then basically send him over to 52-1. Does that make any sense to me? No, not at all.
Okay.
But it's what I have.
I believe that is the way that it works. I think that you would take the plea. I was going to ask if you could do immediate sentencing, but given what you just said, I would want to confirm that they would take it if you did do an immediate sentencing. But if we could set it in front of Judge Barr, and if I could confirm with 52-1, one way or the other, if they want it sent there for sentencing.
Exactly.
Okay.
That's probably going to be the best bet.
Okay.
So that have a date out, and then if they will take it right over, you would likely be able to get Judge Barr just to send it over to 52-1. He'll cancel the sentencing date I give you, and then the world will be back to normal. Not really.
I think
but
that's the best way to go. My inclination, I've had a lot of communication with 52-1 is that the sentence that Judge Barr would actually sentence them to 51 sobriety court, but I would want to confirm that so there's not any issues.
Right, okay. Yeah, and that may make sense in a lot of ways. But there's a lot of other issues regarding that, but okay. All right. So, sir, after all of that, you understand that I will initially be sending you to Judge Barr for sentencing in this matter.
I do.
All right. Now, understanding all of that, you still wish to plead no contest.
Yes, Your Honor.
And to that charge, how do you plead?
No contest, Your Honor.
And you understand that by pleading no contest, you will not have a trial of any kind.
I do.
You had signed an advice of rights form, is that correct?
I have.
Any questions regarding any of those rights?
No, Your Honor.
You understand that you're waiving or giving up all of those rights, inclusive of the rights that are contained in paragraph 5, which are your trial rights.
I do.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you in any way?
No, Your Honor.
You're doing this voluntarily and of your own free will?
I am.
All right. Court has been provided and has reviewed Michigan Department of State Police report for their case number 7389-25. Any objection to the court reviewing that report?
None from the people?
No objection.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you, if between the time that I accept your plea and it's sentencing, that if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
I do, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
No, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. They're really not going to do a pre-sentence interview, but I'll order that. Sentencing in this matter will be set.
It's a township case or a city case.
Oh, township city case gets a different date. This is, no, I'm blaming this all on Mr. Thomas's counsel. No,
Thanks, Your Honor.
I'm kidding.
Township.
I have a township.
June 16th at 10 a.m.
Say it again, June 16th. All right, June 16th, 2026. Time?
10 a.m.
10 a.m. before Judge Barr.
Thank you, Your Honor.
Bond. Thank you. Bond with its conditions. We'll continue. All right. Take care.
Thank you, Your Honor.
Court does call the case. Other people versus Taisha Morgan.
Good afternoon, Your Honor. Raymond Cook for the people.
Good afternoon, Your Honor. Christina Saxon for Taisha Morgan.
Ms. Morgan?
Taisha Morgan.
Okay, thank you.
Okay.
All right. What are we doing?
Your Honor, may I ask for an adjournment? I was just appointed yesterday to this case. I
You were
need to review.
Without objection, probable cause conference will be adjourned to June 18th, 2026, 9 a.m. Bond continue.
Your Honor, since this is your case, I will be out of the country on the 18th. May I?
Since it's my case,
I believe it's your case.
they're all mine. No, I'm kidding. All right. What are you trying to tell me?
I won't be in the
You won't
country.
be in the country? That means this is going to go a lot easier.
I thought so.
All right. What do you want me to do? You want a different date?
Yes, please.
So are you going to tell us when you want the 25th? Will you be back?
No, I won't.
I'm
Ma'am?
not going to ask you. Okay.
May
Do
be
I
in
have to go
11th?
go into the next month?
Either the 11th of June or into the next month.
Well, I'll do
Hello?
the 11th. Hello. June 11th, 2026, 9 a.m.
No,
That's enough time. So thank you.
Thank you.
This is a long adjournment. Court calls the case, People versus Cody Bauman.
This
Good afternoon.
Todd Perkins, who was, but I believe he's having technical difficulties. I don't-
Okay, so Mr. Perkins is it? All right, sir, I'm gonna pass your case to your attorney shows back up.
Thank you.
Thank you. Court calls the case, People versus Tijan West.
That's a non-agreement cook for the people.
Good afternoon, Your Honor. Robin McCoy on behalf of Mr. Tejan West, who is approaching.
Your name, sir?
Tejan West.
All right, I have before me a plea form that indicates defendant would be pleading guilty to an added count 2 of larceny less than 200 the 93-day offense. Upon a successful plea to that charge, count 1 would be dismissed. There is also an agreement that the prosecutor will recommend no upfront jail. That is the court's full understanding of the agreement.
That's correct, Your Honor.
That's our understanding as well, Your Honor.
Have been sworn.
Solemnly swear to affirm the testimony you're about to give the truth, the whole, truth, nothing but the truth, so help you God.
I do. Tejan West.
Sir, it is this court's understanding that you're guilty to the charge of larceny less than 200. Misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that? Still wish to plead guilty?
Yes.
To that charge, how do you plead?
Yes, sir.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form, is that correct? Any question regarding those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are the rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will? And also because you believe that you're guilty of this offense? March 16, 2025, at the location of 4515 Swiss Stone Court, Pittsfield Township, Washtenaw County, State of Michigan. What do you do that makes you think that you're guilty?
I had a card that was not my Apple card that didn't belong to me. I used it.
Okay, so you used it and got some service or goods by using it?
Under $200 or $200.
Okay, I get that. I'll get to that part. But you use that card, you got goods or services that you otherwise wouldn't have been entitled to. Is that correct?
Correct.
All right. Sir, I do have to advise you, between the time of my plea any time of sentence, you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that? Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
None from the defense, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, you have, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14 on probation. Sentencing in this matter will be.
I already know I have a conference. Let's see. 24th. The conference is the 24th through the 26th. So is the 23rd, or is it going to have to be like a Wednesday, like July 1st?
I know we do it this way. What's my next sentence? Well, I have June 10th, I have June 24th, or my July date.
July 8th.
July
8th. July 8th. Yes, that works.
Sentencing will be July 8th, 2026, 9 a.m. And that's before me.
And Your Honor, just for the record, the prosecution is aware he has an issue with the ex-girlfriend. So we have a case tomorrow.
Oh, whoa.
No, it's a misdemeanor.
But why are you throwing his business out? Who's got an issue with the ex-girlfriend? He does?
It's the baby mother.
His mother.
Just press charges on her.
She
So for a chip to.
Okay, I don't know why I'm talking about this.
Because it says you want to know if there's other stuff. I'm just letting you know there's some drama. We just want to make sure there's some drama. We're trying. We're trying to mitigate.
Revisit Ms. McCoy of that baby mama drama.
Yes.
Oh, is this the one? This is not the.
Why this is why we adjourned it out because of that.
Oh,
So that's
ah.
one, because I don't want to be at sentencing and you like, oh, you didn't say anything. No, we let you know we got this disorderly some stuff, and he's got some stuff on her, so they're just letting you know the environment. Yes. Surprise is straight shooter.
No, you don't want to touch. Okay.
Okay.
I don't know what I'm supposed to do with that. I'll be honest with you, but I got it.
No surprises. It's out there. Shooter.
That has never been her MO. But anyway, all right. We'll
For the clients, I don't.
on July 8th.
All right. Thank you, Your Honor. Have a good day.
Bye.
Have a good day.
I'm sorry. Court calls the case. People versus Miko Stewart.
Good afternoon, Your Honor. Raymond Cook for the people.
Good afternoon, Your Honor. I'm Paravine Keller, P 84328, appearing on behalf of Mr. Stewart, who was present to my right. Mr. Stewart, please state your full name for the record.
Goes to Sean Stewart.
Thank you. I have a plea form. Is that what we're doing?
Correct, Judge.
Plea form indicates that the defendant will be pleading to an added count 2 of larceny 200 to 1,000. Will be pleading guilty. That's a 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. There's also a sentencing agreement between the parties to HIDA. That's court's full understanding.
That's correct, Judge.
May I have him sworn?
You solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Goes to Sean Stewart.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of larceny 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that? You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
Signed an advice of rights form, is that correct? Any questions? Please look at paragraph 5. You see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as other rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? No. Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily?
Yes.
Of your own free will? And because you believe that you are indeed guilty of this offense? On April 18, 2025, at the location of 6268 North Maple Road, Northfield Township, Washtenaw County, State of Michigan, what'd you do that makes you think that you're guilty of that offense?
I was in possession of money that was not mine.
Never in possession.
Intentionally, but
Intentionally in possession of money that's not yours?
yes.
It's a very neat way of putting it, Judge. We cover the prongs.
Yeah, I got it. So took somebody's money?
Yeah.
And you had it in your possession. And you didn't have their permission to take their money.
Correct.
Is the amount that you took in excess of $200?
Yes. Yeah.
Yes. Okay. Sir, if I accept your plea, between the time I accept your plea and the time of sentencing, you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that? Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
None from the defense, Judge.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Judge.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. A pre-sentence investigation and a report is ordered at 14A3 probation. Sentencing will be
July 6th at 9 a.m.
July 6, 2026, 9 a.m. before Judge Freshour. Bond Wilkins.
Thank you, Judge.
Thank you, sir.
Thank you.
You do the same. Court calls the case. People versus Davion Smelter.
Good afternoon, Your Honor. Raymond Cook for the people.
Mattler, I think it is.
May it please his honorable court, James King on behalf of Mr. Smetler, who's I believe is present via Zoom and consents to being present via Zoom.
Sir, can you state your name?
Davion Smetler.
All right. And what are we doing today?
Your Honor, defense counsel was recently retained by Mr. Smetler. I'm in receipt of the paper discovery. I'm not sure if the people have emailed me the digital. However, we would like to just adjourn today's proceedings so that I can go through the discovery and we can set the matter for exam if the parties can't come to a resolution.
All right, how much time you need? Will the 18th work for you?
Court's indulgence.
I have that. I do. I went and bought some indulgence.
Yes, I believe the 18th will work.
I don't use it, but the 18th will work, counsel.
Yes.
All right. No, hearing no objection. I'll adjourn this matter June 18th, 2026, 9 a.m.
Thank you, Ben. Sir, if you can just email us a copy of your appearance to PA-discovery@washtenaw.org, we'll be able to get everything. I don't see that we have a copy of your appearance in our files. It's probably why discovery is taking a little bit to get to you.
Very well.
All right. Thank you. Bond will continue.
Thank you.
Court calls case, People versus Michael Smith. Oh, boy. Wonder when her case.
Wouldn't be a Thursday without me.
That's it.
Christina Costantino appearing with and on behalf of Mr. Smith. Mr. Smith, can you please unmute and state your name for the record?
Michael Smith.
All right. What are we doing?
Here's the date and time set for PCC. We are, dare I say, very close to a resolution. I do think one additional adjournment would help facilitate said resolution, though.
All right.
Asking for an adjournment.
11th or 18th, which one would you prefer? I don't know why I'm so nice.
Either one really works, but I think I'll be here already on the 11th. So could we do the 11th?
This matter's adjourned June 11th, 2026, 9 a.m. Bond continued. Thank you.
Very much, Judge.
All right, thank you.
Court calls the cases of the People versus Peter Vasher.
Read it over to the people, Your Honors.
Oh, goodness. Christina Costantino on behalf of Mr. Vasher. Judge, he was just in here.
Is this like Creature's client?
He really was. He was here.
He was here.
I talked to him.
Not a spirit. Okay.
If the court wouldn't mind me checking the hallway because he was here. The strangest thing.
Was Feaster going out to help you or no? No, he wasn't. He's just helping anybody.
Yes.
Oh, my bad.
Thank you. And up right here. Mr. Please state your name for the court.
Peter J. Vasher.
Thank you. Okay.
We have a problem. You had the
Yes,
bond.
Judge.
Go ahead. Let's
Yes, Judge.
that for a
Yes, Judge, I did receive a copy of the bond violation report. My understanding is that Mr. Vasher did not report to community corrections as required for testing. It's my understanding that Mr. Vasher was released from, he was originally in Washtenaw County Jail. He was then transferred to Wayne County Jail, and that he was just released from Wayne County Jail yesterday. It's further my understanding that he did speak to community corrections yesterday. He has indicated they did tell him to report to community corrections. Unfortunately, he has indicated that his car broke down as he was going to community corrections. I did, Judge, I called him. He was clearly on the side of the road with a broken down car when I spoke with him yesterday. It really sounded like it, Judge. I mean, cars driving by, maybe some honks, it sounded like it. So, Judge, long story short,
this is not short. Go ahead.
I did speak with Mr. Vasher. He is aware he needs to go to community corrections. He has the funds in his pocket, which he showed me today, to pay for the testing. He's indicated he will go across the street today after this hearing and test as required. So we would ask the court to give him an opportunity to do that. He is 68 years old. He has a slew of health conditions, including COPD and cirrhosis of the liver, that incarceration or continued incarceration would make significantly difficult for him. So we'd ask the court to give him an opportunity to go to community corrections and test.
But he just got out yesterday. Well, he got out and then, okay. I'm going to,
Did you get out of jail yesterday?
8 o'clock at night.
Okay.
So that's a yes.
So,
All right.
yeah.
Okay. Sir, get yourself over. Get yourself over to community corrections, okay? And get yourself set up. Got that? Know where they are?
Right across the side.
That's right. What road did you break down on?
Huh?
What road was your car on when it broke down?
94.
Wow. Okay. Well, you got here safe. Don't worry.
It did sound like it, Judge.
I heard honking and all right. And then you want this adjourned?
Yes, Judge, I was just appointed to Mr. Vasher's matter yesterday, so I do
11th.
discovery.
11th work for you?
Yes, Judge, that would, thank you.
Both of your matters are adjourned to the 11th. Get yourself over to community corrections. Okay?
I'm there.
Pardon?
I said I'm there.
Okay.
There.
Very good. All right. Take
Thank you
care.
very much, Judge. All right, we're all set.
Thank you. Court calls the case of the People versus Lucretia Pender.
Your Honor,
I said it wrong. Ms. Pender, can you state your name, please?
Good afternoon, Your Honor. Justin Zaid appearing on behalf of Ms. Pender, who is present and consents to appear via Zoom. Ms. Pender, can you unmute, state your full name?
Lucretia Pender.
And Your Honor, this is a case where I'm going to apologize to defense counsel and to the court. We're working towards a resolution. I got a receipt from defense counsel on Tuesday. Unfortunately, the court a little bit longer Tuesday than I anticipated, and I was not able to follow up on that message. So I've not been able to do my due diligence to confirm that the money has been paid. I would be asking for a brief adjournment just so I can call me sure that that's gone through and that we're all set to go. I again apologize for the inconvenience.
Counsel, I'll vouch for him that he was here a long time.
Fair enough, Your Honor.
I was right here with him. So, all right. Will the 11th or the 18th work for you, counsel? Which is better?
I'll make the 11th work. Thank you, Your Honor.
All right. Probable cause conference will be adjourned June.
A courtroom hearing takes a dramatic turn as multiple defendants face serious decisions involving drug charges, probation violations, bond requests, and upcoming jury trials. One emotional moment comes when an inmate asks the court for another chance after spending months working through rehabilitation programs behind bars. He explains that he wants to reunite with his children and prove he can follow the rules, but the judge delivers a tough reality check, explaining that the decision is now out of the court's hands and rests with the parole board. The hearing also features a defendant facing multiple charges, including assault on a law enforcement officer, evading arrest, and tampering with evidence. When he appears without an attorney, the judge issues a stern warning that time is running out and that excuses will not stop the case from going to trial. Another major moment involves a drug case where a defendant accepts a plea agreement after prosecutors describe evidence allegedly linking her to narcotics discovered during a traffic stop. The judge carefully explains the consequences before accepting the plea and imposing strict probation conditions. Later, a defendant asks to have his bond reinstated after it was revoked because of new charges in another state. During cross-examination, prosecutors confront him about reckless driving, leaving the scene of an accident, and other allegations, while the court weighs whether he deserves another opportunity. From second chances to harsh warnings, this hearing is packed with courtroom drama, difficult decisions, and life-changing consequences. Do you think defendants who pick up new charges while already out on bond deserve another chance at release, or should their bond stay revoked? Let me know in the comments.